Hello, everyone. Sorry again about our slight technical problems caused by a Mac update. Now, there's a disclaimer on the screen saying broadly what I say is not to be treated as legal advice, and nobody else at Five Stone is to be blamed for it either. Today is about truth and lies, and how it is that judges are supposed to tell the difference between them. The structure of today is going to be as follows. Why it is particularly relevant now. And then the bulk of the talk will be about how it is that judges are instructed to identify lies, how lies are detected. The third part will be about remote trials and specifically demeanor of witnesses. And then at the end, I'm going to put up 3 slides which have the citations for all of the judgments and the authorities that I'll be referring to. But aside from those 3 slides at the end, and I'll warn you when I'm going to put those up, I'm not going to use PowerPoint because I don't find it particularly helpful most of the time. So, start with why it's relevant now. I expect, like me, over the last year or so, you've been having lots of skirmishes about whether trials should be conducted remotely or in person. Now, you tend to be on one side or the other, depending on which way you think favours your client. But I was involved in one of those recently. We wanted the trial conducted remotely. My people were accused of being fraudsters. As it turned out, they were. One of them confessed in evidence. But the other side referred to the judgment of Mr. Justice Marcus Smith in the case of Bilter and TFS. And the following passage was the bit that was particularly important to them. Marcus Smith said, the caution with which a court should approach the question of remote hearings, where witnesses are to be heard, reflects the importance of witness evidence in English civil procedure and the significance of cross-examination. As was noted in the Queen on the application of Dutter, the general rule is that oral evidence given under cross-examination is the gold standard because it reflects the long-established common law consensus that the best way of assessing the reliability of evidence is by confronting the witness. It follows from this that any form of artificial intermediation interposed between the questioners of a witness and the judge hearing that witness's evidence must be a derogation from the gold standard. Now, before you dash out and deploy that in your most recent skirmish, it's important to be aware that that was then overturned in the Court of Appeal, but without reference to that specific passage. But that specific passage, for what it's worth, I don't really agree with it. But the question is, it seems to me that the question the judge in our case was faced with, and the question in all of these sort of skirmishes, is whether anything of value is lost over a remote connection. And the way to answer that is to establish how it is that the court should evaluate evidence. And so that's the purpose of this talk. So how does a judge tell whether or not somebody's lying? Now, this isn't just of application in these sort of little arguments about remote trials. That is at the very core of what we do, isn't it? You know, we want, some trials are decided on very neat little technical legal arguments, but most of the time, one lot's lying and the other lot are not lying, or are not lying quite so much. And getting the judge to the point where they believe your side and not the other side is usually enough to win. And so you've got to get into the mind of the judge to work out what it is that's important to the judge. Now, the starting point for most of the sort of discussion around this area is Mr. Justice Bingham's essay, The Judge as Juror, published in 1985, in which he said this: the main tests needed to determine whether a witness is lying or not are, I think, the following. 1, the consistency of the witness's evidence with what is agreed or clearly shown by other evidence to have occurred. 2, the internal consistency of the witness's evidence. 3, consistency with what the witness has said or deposed on other occasions. 4, the credit of the witness in relation to matters not germane to the litigation. And 5thly, the demeanor of the witness. Now, Bingham observed, and most judges, it seems to me, would agree, that the first 3 are useful pointers. Consistency of the evidence with what is clearly shown to be true, internal consistency within the statement, within that witness's evidence or the witness statement itself, consistency with earlier statements made by that witness. As to the 4th, credibility on matters not germane to the litigation or credibility on collateral issues, Bingham was cautious about how useful that is. He said, "I strongly suspect that many honest witnesses who would do their very best to ensure that the substance of their evidence was reliable and accurate would nonetheless be willing to prevaricate, or if necessary lie, when asked why they lost their previous job or how their first marriage came to break up." Cross-examination as to credit is often, no doubt, a valuable and revealing exercise, but the fruits of even a successful cross-examination need to be appraised with some care. So that is something like you have a Lucas direction in criminal cases, which, although it's a 3-part direction to a jury, paraphrasing rather dramatically, just because somebody's lying about something doesn't mean they're lying about everything. And just because they're lying about something of relatively minor importance certainly doesn't mean that they're lying about the very essence of the case. Now, the fifth of Bingham's 5 tests for veracity is demeanor. And we'll come back to look at that in much more detail towards the end. So looking at how that sort of extrajudicial theory has been applied, there's a very useful first instance decision in 2018 in a case called Kimathi against the Foreign and Commonwealth Office. That was it's a judgment of Miss Justice Stewart. It's a very long judgment because it was a very long-running and substantial case. Each side had, I think, 9 counsel. The claimant had 3 silks. It was claims arising out of the Kenyan emergency. So allegations of abuse and torture, which was said to have taken place in the early 1950s or through much of the 1950s in Kenya by the colonial authorities. But Stewart very helpfully, Miss Justice Stewart very helpfully summarises what he described as the learning from first instance judges. And he began, as most of the modern analysis does, with the case of Guestman and Credit Suisse, which was the judgment of Miss Justice Leggett, as he then was, in 2013. And Stewart paraphrased it in this way: we believe memories to be more faithful than they are. 2 common errors are to suppose, 1, that the stronger and more vivid the recollection, the more likely it is to be accurate, and 2, that the more confident another person is in their recollection, the more likely that is to be accurate. Next, the point that memories are fluid and malleable, being constantly rewritten whenever they are retrieved. This is even true of flashbulb memories, a misleading term, i.e. memories of experiences of learning of a particularly shocking or traumatic event. Now, anyone who's had to look recently through the practice direction on witness statements for trials will recognise some of that language. Some of that has found its way into the sort of guidance that's been put in by the Rules Committee. Next, Stewart paraphrasing still from Guestman, events can come to be recalled as memories which did not happen at all, or which happened to somebody else. The process of civil litigation itself subjects the memories of witnesses to powerful biases. Considerable interference with memory is introduced in civil litigation by the procedure of preparing for trial. Statements are often taken a long time after relevant events and drafted by a lawyer who is conscious of the significance of the issues in the case, of what the witness does or does not say. The best approach for a judge is to base factual findings on inferences drawn from documentary evidence and known or probable facts. This does not mean that oral testimony serves no useful purpose, but its value lies largely in the opportunity which cross-examination affords to subject the documentary record to critical scrutiny and to gauge the personality, motivations, and working practices of a witness, rather than testimony of what the witness recalls of particular conversations and events. Above all, it is important to avoid the fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. The next authority or the next judgment that Stewart referred to was the case of Lesho and Lesho. Now, this was a judgment of Mr. Justice Mostyn in 2017. It's very different from Gestemin and Credit Suisse. Gestemin and Credit Suisse was a document-heavy commercial dispute. Lesho and Lesho was family proceedings. So it was he had a French father, a mother originally from Bangladesh. The family lived in Dubai for most of the time, but it ended up with Children Act proceedings and divorce proceedings in this jurisdiction. And so Mostyn, so really its purpose is to show that the Gestemin principles do apply more broadly than in a strict commercial context. So Mostyn cited extensively from Gestemin and some other authorities. And Stewart extracted the following from his judgment. There's a passage which read, "Witnesses, especially those who are emotional, who think they are morally in the right, tend very easily and unconsciously to conjure up a legal right that did not exist. It is a truism, often used in accident cases, that with every day that passes, the memory becomes fainter and the imagination more active. For that reason, a witness, however honest, rarely persuades a judge that his present recollection is preferable to that which was taken down in writing immediately after the incident occurred. Therefore, contemporary documents are always of the utmost importance." And then the final judgment that Stewart in Kimathi was referring to was the case of Kamal and Sheer County Council, again in 2017, again a judgment of Mostyn, but that was a care case. So that was a case involving historic allegations of historic sexual abuse, very, very serious allegations. And Mostyn said this: "The general rule is that oral evidence given under cross-examination is the gold standard, because it reflects the long-established common law consensus that the best way of assessing the reliability of evidence is by confronting the witness." Now, you'll recall from the beginning, that is the part that Marcus Smith was referring to in Bilter. But what is interesting about its reliance or its use in Bilter is, firstly, it's slightly inaccurately attributed. Marcus Smith was referring to it as being a passage from the Queen on the application of Dutter, whereas in fact Dutter was just taking this entire extract from Kimathi, and Kimathi was itself a summary of what was said by Mostyn and Kamal and Sheer. But more importantly, what Mostyn was saying in Kamal and Sheer was very heavily qualified, because he went on from that passage about the gold standard to say, however, oral evidence under cross-examination is far from the be-all and end-all of forensic proof. He referred again to Gestemin and then said, this approach applies equally to all fact-finding exercises, especially where the facts in issue are in the distant past. This approach does not dilute the importance that the law places on cross-examination as a vital component of due process, but it does place it in its correct context. And it seemed to me that was what was lost in Bilter. The impression that was given from cherry-picking that extract was that the gold standard of face-to-face cross-examination is something never to be interfered with, and essentially is the cornerstone of determining factual issues in civil litigation. And I think that puts it a bit too high, really. So we can see from those from Kimathi that the Gestamin approach applies beyond the purely commercial context, because it's applying there in care cases, in divorce and Children Act cases, and also in sort of international tort cases, really, which is Kimathi itself. But there are limitations to it. It shouldn't be slavishly followed, because in 2019, the Court of Appeal heard an appeal in the case of Cogan and Martin. And Lord Justice Floyd referred to Gestamin and said this. The judge read Miss Justice Leggett's statements in Gestamin as an admonition against placing any reliance at all on the recollection of witnesses. We consider that to have been a serious error in the present case for a number of reasons. First, Gestamin is not to be taken as laying down any general principle for the assessment of evidence. It is one of a line of distinguished judicial observations that emphasise the fallibility of human memory and the need to assess witness evidence in its proper place alongside contemporaneous documentary evidence and evidence upon which undoubted or probable reliance can be placed. But a proper awareness of the fallibility of memory does not relieve a judge of the task of making findings of fact based upon all of the evidence. Heuristics or mental shortcuts are no substitute for the essential judicial function. Now, I was trying to emphasise in that the part that says putting it in its proper place alongside contemporaneous documentary evidence, which was really what Gestamin was getting at, and evidence upon which undoubted or probable reliance can be placed. And I'm emphasising that bit because some documents don't, some cases don't have a lot of documents, but almost all cases have either agreed or indisputable facts. And it's against them that the witness evidence is tested. And that's really, to my mind, that is the essence of how a judge works out whether a witness, or should work out, whether or not a witness is telling the truth. Now, most of the cases that I've referred to are slightly beyond the day-to-day for most of us. I mean, if most of us found ourselves in a care case or even in an international historical torture and abuse case, we would be somewhat out of our comfort zone. But what is rather more bread and butter for most of us is Wrangle and Brunt this year. Wrangle and Brunt was an interesting case about an allegation of a forged will. And it was one of Master Tedderson's last judgments, and probably rather sadly for him, was overturned by Miss Justice Green on appeal. Now, Wrangle and Brunt, well, Miss Justice Green said this. He said, in cases of fraud, where the credibility of witnesses is critical, I prefer to rely on what was said by Lord Justice Robert Gough in the Ocean Frost. That's a case actually called Armagas Limited and Mundogus, brackets the Ocean Frost in 1985. Robert Gough said this, speaking from my own experience, I have found it essential in cases of fraud, when considering the credibility of witnesses, always to test their veracity by reference to the objective facts proved independently of their testimony, in particular by reference to the documents in the case, and also to pay particular regard to their motives and to the overall probabilities. It is frequently very difficult to tell whether a witness is telling the truth or not, and where there is a conflict of evidence, such as there was in the present case, reference to the objective facts and documents, references to the witness's motives and to the overall probabilities, can be of very great assistance to a judge in ascertaining the truth. Now, Wrangle and Brunt was, at one point, Miss Justice Green described it as not a Gestamin case. Now, it seems that by that he really meant that there was not a sort of body of agreed or of indisputable documentary evidence, like you have sometimes in a commercial case where there is an extensive body of contemporaneous emails or something. Wrangle and Brunt didn't involve that. Wrangle and Brunt involved a will which was found 10 years after the supposed testator died, and in which it was found by a man known to the family who was a convicted fraudster, as I said, 10 years after the death. It had been drafted by the convicted fraudster, and it had been signed by the convicted fraudster. So he said it had been signed by him at the direction of the testator, and the two attesting witnesses were associates of the convicted fraudster. So all of those, so it seems, were agreed facts. So although Wrangle and Brunt wasn't a Guesstiman case in the sense that it didn't have this vast body of documentary evidence, virtually every document in that case was disputed. The will itself, the notes that the fraudster had made at the time when he discovered the will, or at the time at the time when he says that he prepared the will. There were objective facts and probabilities against which to weigh the veracity of the evidence, and it seems to me in Wrangle and Brunt that the error that Tellison fell into was starting with the documents. So he started with the documents and seemed to broadly say they are not suspicious on their face, and then balance the evidence against that, whereas he should have been looking at the entire evidential picture. So the facts that I've relayed to you, it's found by a convicted fraudster 10 years afterwards, it's signed by the fraudster, it's witnessed by his associates. Those are agreed facts or indisputable facts, and they are, in a will case, inherently extremely suspicious. And so the appropriate way to appraise the evidence, to work out which side is lying, is to be weighing that evidence against those objective and highly suspicious facts. So is the approach sort of in modern times explained in Guesstiman and the other authorities that we've been to, is it any different in a case where you don't have a lot of documents? Well, in my submission, it isn't. In my submission, rather, I say it isn't, because you almost invariably have some agreed facts, and even if the other side are totally and utterly unreasonable and you can't get them to agree anything, there are facts that really sort of are undeniable. You know, for example, if something is said to have happened at 7 o'clock in the evening, well, the time of year that took place will determine whether or not it was light or dark. You know, if it happened in June, then 7 o'clock was daylight. If it happened in January, 7 o'clock was nighttime. So you have those sort of facts. But also in our cases, some of them are very much like Guesstiman. So a heavyweight sort of offshore trust bit of litigation will often look very much like any other sort of commercial dispute. There will be minutes of trustees' meetings, and there'll be an extensive body of email correspondence and documents about dealing with the assets and all that sort of thing. So you'll have those to work from. But in, say, an ordinary domestic succession type dispute, you won't have that type of documentary record, but you will have other things. So, you know, if you're trying to work out whether two people were living together as husband and wife in the 2 years before they died, well, if you analyze, or if you can get copies of all of their social media posts and their text messages and their emails, etc., you may well be able to form an impression, or those documents may make clear certain facts from which certain inferences can be made. And you know, if the farmer promises his daughter the herd, you will have again her social media, her emails and her text messages, her communication with her friends and her family. You would expect very, very little happens without leaving any sort of trace in the modern world. Or you may simply need to go back to people's bank statements and people's telephone records and things to work out whether a person was in a particular location on a particular day, or in a particular location at a particular time. You might be able to see. Well, recently, in a case I was doing, the most important bit of evidence was probably somebody's cinema receipt from having bought a cinema ticket in a particular place when they had been saying that they were somewhere else entirely. So I don't think a case has to be like Gestamin in order for these principles to apply. It's very rare that a case is going to turn sort of in the abstract on the way in which a witness is performing in the box as compared to the way in which another witness is performing in the box. Now, the other element of these of the analysis is probability. So it's been referred to in various bits in passages that we've gone to. Overall probabilities, what is sort of more likely to have happened, etc. Now, quite often in more serious with more serious allegations. So in our particular area, where people are accused of forging wills or forging other documents, forging trust instruments or minutes or something like that, or undue influence perhaps, or fraudulent calumny. It is often said that there is some more difficult threshold to meet. The more serious the allegation, the harder it is to prove. That is not quite right. There's a suggestion in Phipson that the burden of proof in civil cases is a flexible one, but it is said almost everywhere that the burden of proof is on the balance of probabilities, and that, of course, is absolutely right. But the neatest way of approaching probability when you have serious allegations is by reference to a case called Re B, Children Care Proceedings Standards of Proof, and that was a judgment in 2009. The leading judgments are given by Lord Hoffman and Baroness Hale, but Baroness Hale illustrates the point very, very nicely, because at paragraph 72, she explained, as to the seriousness of the allegation, there is no logical or necessary connection between seriousness and probability. Some seriously harmful behaviour, such as murder, is sufficiently rare to be inherently improbable in most circumstances. But even then, there are circumstances, such as a body with its throat cut and no weapon to hand, where it is not at all improbable. Other seriously harmful behaviour, such as alcohol or drug abuse, is regrettably all too common and not at all improbable. Nor are serious allegations made in a vacuum. Consider the famous example of the animal seen in Regent's Park. If it is seen outside the zoo, on a stretch of greensward, regularly used for dog walking, then of course it is more likely to be a dog than a lion. If it is seen in the zoo, next to the lion's enclosure, when the door is open, then it may well be more likely to be a lion than a dog. So it's a matter of presenting the surrounding circumstances around these key events in such a way as to demonstrate that one is more probable than the other. So turning then back to the original question, what is it that is lost in a remote trial? Or what is it that might be obscured? And it seems to me that it's demeanor. There was one of these skirmishes took place about whether it should be a remote or in-person trial in a case called a local authority against a mother in 2020, and it was the judgment of Miss Justice Lieven. she was asking the question, or assessing the question, whether the judge will be in a less good position to judge whether or not the witnesses are telling the truth if the case is conducted remotely. And she said this: having considered the matter closely, my own view is that it is not possible to say, as a generality, whether it is easier to tell whether a witness is telling the truth in court rather than remotely. Some people are much better at lying than others, and that will be no different whether they do so remotely or in court. Certainly in court, the demeanor of a witness, or anyone else in court, will often be more obvious to the judge, but that does not mean that it will be more illuminating. Now, what do we mean by demeanor? Well, Lord Justice Leggett, as he had become by 2018, explained in The Queen on the application of SS against the Secretary of State for the Home Department, that the term demeanor is used as a legal shorthand to refer to the appearance and behaviour of a witness in giving oral evidence, as opposed to the content of the evidence. So, is demeanour of any value? Is what is lost or potentially obscured of any value? Well, the oldest of the materials that I'll be putting up at the end is an article by Mr. Justice McKenna entitled Discretion from 1973, in which he said, "I question whether the respect given to our findings of fact based on the demeanour of the witnesses is always deserved. I doubt my own ability, and sometimes that of other judges, to discern from a witness's demeanour or the tone of his voice whether he is telling the truth. He speaks hesitantly. Is that the mark of a cautious man, whose statements are for that reason to be expected, or is he taking time to fabricate? Is the emphatic witness putting on an act to deceive me, or is he speaking from the fullness of his heart, knowing that he is right? Is he likely to be more truthful if he looks me straight in the face, rather than if he casts his eyes on the ground, perhaps from shyness or a natural timidity? For my part, I rely on these considerations as little as I can help." And Leggett, now since 1973, there has been significant progress in work on the human mind. And so Leggett, Lord Justice Leggett, had the benefit of that in Queen on the Application of SS. And he went on to explain matters in more detail. Empirical studies confirm that the distinguished judges from whom I have quoted were right to distrust inferences based on demeanour. The consistent findings of psychological research have been summarised in an American law journal as follows. Psychologists and other students of human communication have investigated many aspects of deceptive behaviour and its detection. As part of this investigation, they have attempted to determine experimentally whether ordinary people can effectively use non-verbal indicia to determine whether another person is lying. In effect, social scientists have tested the legal premise concerning demeanour as a scientific hypothesis. With impressive consistency, the experimental results indicate that this legal premise is erroneous. According to the empirical evidence, ordinary people cannot make effective use of demeanour in deciding whether to believe a witness. On the contrary, there is some evidence that the observations of demeanour diminishes rather than enhances the accuracy of credibility judgments." And Leggett went on, "While the studies mentioned involved ordinary people, there is no reason to suppose that judges have any extraordinary powers of perception, which other people lack in this respect. This is not to say that judges or jurors lack the ability to tell whether witnesses are lying. Still less does it follow that there is no value in oral evidence, but research confirms that people do not in fact generally rely on demeanour to detect deception, but on the fact that liars are more likely to tell stories that are illogical, implausible, internally inconsistent, and contain fewer details than persons telling the truth. One of the main potential benefits of cross-examination is that skillful questioning can expose inconsistencies in false stories." So that's going to bring us back round to those five forms of testing identified by Bingham. But we'll look at them again at the end. Now, if your practice involves a reasonable degree of sort of international work or cross-border estates and trusts, then this sort of analysis about demeanour is going to be all the more important. Because, as Leggett observed at Crown on the Application of SS, the reason for distrusting reliance on demeanour are magnified where the witness is of a different nationality from the judge and is either speaking English as a foreign language or is giving evidence through an interpreter. Lord Justice Scrutton once said that he had never yet seen a witness giving evidence through an interpreter as to whom I could decide whether he was telling the truth or not. And in his seminal essay on the judge as juror, Lord Bingham observed that if a Turk shows signs of anger when accused of lying, is that to be interpreted as the bluster of a man caught out in deceit, or the reaction of an honest man to an insult? If a Greek similarly challenged becomes rhetorical and voluble, and offers to swear the truth of what he has said on the lives of his children, what, if any, significance should be attached to that? If a Japanese witness accused of forging a document becomes sullen, resentful, and hostile, does that suggest that he has done so, or that he has not? I can only ask these questions, I cannot answer them. And if the answer is given that it all depends on the impression made by the particular witness to the particular case, that is, in my view, no answer. The enigma usually remains. To rely on demeanor is in most cases to attach importance to deviations from the norm when there is, in truth, no norm. So, is what is obscured or lost of any value? Is demeanor of any value? Well, it rather seems that it isn't. Because the truth, the veracity of a witness statement or of a witness's evidence is tested by certain means. So it's tested by consistency with agreed, irrefutable, or probable facts. It's tested against documents, against the objective facts, against motive, and against overall probabilities. It's also important to test it for internal inconsistency or internal consistency within the witness statement itself and within the oral evidence that the witness gives during during cross-examination, and to test it for consistency against earlier statements. Frequently in our cases, there will be multiple statements from a particular witness. But there are matters which are considerably less useful and which must be approached with extreme caution. And so those include demeanor, tone of voice, hesitation, emphasis. So it does seem to me that what is obscured, what is potentially lost over a remote connection, really ought not to assist a judge in anything other than a most exceptional case. And so before putting up the slides, I just want to mention why all this analysis might be of some use to us. Well, first of all, it's very important to know, so it seems to me, how a judge decides who wins. And this is, in most cases, this is it. This is how it is done, or how it should be done. And it highlights, well, it's not just limited to remote trials, those sort of skirmishes about remote trials and in-person trials. It's a much broader application. And it again highlights the importance of witness statements. So I've given a previous webinar about witness statements. They are, in most cases, I believe, that it is the witness statements that win or sometimes lose the case. They are the most important piece of work, and they really need to be done by people with considerable skill, rather than sort of being delegated to the most junior person in the team. Now, the important bits of them are, they've got to be the witness's recollection. Now, that ought to be obvious, I'm sure, to everyone. But the difficulty is, if there's something in a witness statement which isn't quite the witness's recollection, when the witness is being cross-examined, what they're likely to say is what their actual recollection is. And if there's then an inconsistency between what's in the statement and what they've said in open court, that's going to be pounced on by the other side, and it could well be extremely detrimental to that witness's credibility. The next thing to consider is that the statements must be consistent, both internally. So you don't want to find yourself in a position where paragraph 10 is incompatible with what is said in paragraph 37, but also between statements and the irrefutable documents. So now this gives rise to sort of various ethical considerations as to what documents one should be showing to witnesses in the course of preparing their evidence and things, and that's beyond the scope of this. But so far as possible, it is undesirable to have paragraph 4 of the witness's first witness statement be incompatible with paragraph 7 of their third witness statement, and so that needs to be done carefully and skillfully to ensure it doesn't happen. because it does happen. Anyone who's done a lot of trials will know that happens all the time, and it happens when statements have been prepared by quite serious and skillful people. The next thing to consider is the timing of preparing witness statements. So if you've got a case where witness evidence is going to be incredibly important, consideration ought, I would suggest, to be given to getting that witness evidence prepared early. Because if I give you an example, if you had a will that was executed in January this year, and the testator dies in March, and even now it is clear, the clients come to you and it is clear that there are going to be some important factual disputes. Well, if you get the and you can sensibly identify what they are sufficiently to prepare a witness statement, but if you get down a witness statement that is sworn and dated now, well, they have been prepared. Those statements have been prepared within 6 months of that event. Now, there might from here be another year of correspondence backwards and forwards, and sort of caveats and put up and shut up orders and people issuing and that sort of thing. And then you get to issue, and then of course then you've got the pleadings, and then you've got CCMCs and budgeting and disclosure, and then you've got witness statements. So it could be 2 years from here or 3 years from here before there is a direction for the exchange of witness statements. So if your witness statements are dated now, are prepared within 6 months of the key event, and before your witness's recollection has been so extensively contaminated by the process of civil litigation and motivation and bias and all that sort of thing, and the other sides are dated 3.5 years after the key events, and after 3.5 years of having seen lawyers preparing written arguments about all of the material factual disputes. Now, if you're the judge approaching that, one would hope that the judge would put slightly more reliance on your witness statements that were prepared contemporaneously, or as close thereto as they can be. So those are the three things, or those are the things that can be done in preparation. They're all about really witness statements, so it seems to me, and evidence gathering. Well, they're about witness statements. The other bit is about evidence gathering. So as I said earlier, very little happens without leaving a footprint. So if you're going to be having a serious factual dispute, it is important to drill down into as much detail as you possibly can. So to be getting all of the social media posts and the text messages and the emails before they're lost, and to be getting bank statements and telephone records, and to be getting all that material so that you can present sort of an irrefutable factual picture against which your evidence and the other side's evidence can be tested. But then the last thing is, if you have a witness who doesn't do so well, who sort of seemed to you was going to be sort of quite confident and sensible, and then when they give their evidence, in terms of they're right, they can't make eye contact with the judge, they're shuffling around, they're fiddling with things, their eyes are all over the place, they're fidgeting, they give a terrible impression. Not all judges know about all of this analysis. Not all judges know what you now know. So if you are concerned that a judge has formed a very negative impression from the demeanor of one of your witnesses, then it would be very useful if before they wrote their judgment, it was brought to their attention that negative impression should carry no material weight, and you bring them back to the inherent probabilities of the case and to the undisputed facts, which hopefully are more favourable to you than the impression that your witness gave. And by doing that, you might be able to row back from what was a very effective cross-examination by the other side. Now, I promised that I would put up some slides, so I'll do that now. So these are the authorities that I went through on assessing witness credibility. I'll leave it up just for a minute in case anyone wants to take a screenshot. But it may be simpler that if you want these lists of citations, just send me an email afterwards and I'll send them on to you. So that's assessing witness credibility. This one is about probability. So the one that I was referring to is in re B there. But it's worth being aware of the earlier two, although you'll find most of the relevant extracts in re B. And then this is remote trials. So Bilter, that's where we began. That's Bilter being overturned in the Court of Appeal. And that is Mr. Justice Lieven's judgment in a local authority against a mother. Now, I don't think that we have any questions. And so that is all for today. You're obviously welcome, as ever. If you disagree with some of what I've said or everything that I've said, feel free to give me a call to discuss it or send me an email. But otherwise, thanks for joining.